A Plus Care Solutions, Inc. And before I begin, I would request 3 minutes to be reserved for rebuttal time.
All right, 3 minutes.
This appeal presents a very straightforward question. Did the Chancery Court abuse its discretion by denying A Plus Care's motion for permissive intervention, despite undisputed common issues of law and fact, and without addressing the mandatory factors to be considered while utilizing equitable discretion, as noted in Rule 24.02 of the Tennessee Rules of Civil Procedure? And the record shows that it did. To understand why A Plus Care moved to permissively intervene in the first place, this court only needs to look at the sequence of events. A Plus Care is a defendant in a Madison County healthcare liability case brought on behalf of Patrick Harris, the conservatee in this case, by one of his co-conservators, Bertha Walker. A Plus Care challenged standing in that case because the original 2009 conservatorship order did not remove Mr. Harris's right to bring suit in his own name or to do any act of legal significance. The Circuit Court denied A Plus Care's motion to dismiss in part because of the Chancery Court. The Chancery Court issued a nunc pro tonc order in January 2025, which retroactively removed additional rights from Patrick Harris, including the right to do things in legal significance or bring suit in his own name. And the Circuit Court clearly indicated in the record it would reconsider.
Is your position that Mr. Harris is competent to bring suit in his own name?
Your Honor, my position is that the Chancery Court made that decision in 2009 when it was presented with evidence, there was a hearing. And so, yes, it is our position that he is competent and that this nunc pro tonc order is invalid. And
So
that,
what do you base that evidence on, or base that position on?
I base that position on the conservatorship statutes. The conservatorship statutes in Tennessee are pretty clear, requiring that a conservatee, at least in the original, get notice of the hearing. They get appointed sometimes in a guardian ad litem or a counsel. If it's not waived, there needs to be a hearing on the least restrictive remedies because a conservatorship is supposed to be the least restrictive it could be. And the court in 2009, when presented with that evidence, which is in the record, including, I believe, some affidavits from medical professionals in 2009, the court had a hearing. The court made a decision on what specific rights Mr. Patrick Harris was was incompetent to do himself and gave them to his conservators.
And those affidavits state, both of them, that Mr. Harris is a disabled person due to mental retardation and is unable to manage his personal and financial affairs.
Yes, Your Honor, and that was removed from him in 2009. However, when you look at the conservatorship statutes, it's 344108. It lists out what a chancery court could remove, not limited, but there are, I believe last time I counted, 15 things that a chancery court could remove. They make it pretty easy to create an order that complies with Tennessee law. And in there are some of the rights that were removed from Patrick Harris in 2009. And one of those enumerated rights in the statute is to do any act of legal significance and separately to bring a suit in one's own name, and neither one is identified in the 2009 order. And so the chancellor at that time clearly made some decisions when that hearing was occurring. And there is no memorandum or notation in the record, which is required for a nunc pro tonc order, that states this is what I actually meant. And again, plain language of Tennessee conservatorship statutes, along with supportive case law, state that general overbroad language like without limitation or what have you are not enough to take away rights from a conservatee. You need to specifically enumerate those, and the statute says if it's not in the order, they retain that right.
What about what the circuit court relied upon?
The circuit court relied upon the nunc pro tunc order in January 2025 and stated that the chancellor who heard that, which was, the nunc pro tunc order was well over a decade after the original order, and said this is what the chancellor removed Patrick Harris's right to do any act of legal significance in 2025 and made it nunc pro tunc, and so that's what they relied on. They said if you file a motion for permissive intervention and the chancellor says, no, I didn't actually mean that in 2009, then we can...
Chancellor.
Excuse me?
Same chancellor who entered the 2009 order.
Yes, Your Honor. Same chancellor, but it doesn't negate the requirements for a nunc pro tunc order. In Thomas v. State, as I cite in my principal brief, and I believe and also in my reply, the Supreme Court has made it clear that a nunc pro tunc order cannot be entered unless there is a writing, memorandum, or notation from the judge, and who granted it back at that time to say, this is what I actually meant. And Your Honor, Your Honors, with
What about the other reason the circuit court allowed the motion or allowed the litigation to proceed?
Yes, Your Honor, and we disagree with that as well. We filed an interlocutory appeal, which was denied, but the other reason was
But you have an appeal of that issue in that case, don't you?
Not right now. Well, we have an interlocutory
But
appeal going.
You have the right to appeal
Yes,
that.
Your Honor.
So actually, you're getting two bites at the apple on the standing issue, aren't you?
No, Your Honor, they're two separate issues.
But it's the same legal issue, whether or not the conservator here has the right to file a lawsuit on behalf of the ward. Isn't that the issue in both cases?
Correct, but the
But
circuit...
you're getting two bites at the apple, aren't you?
No, Your Honor, because the circuit court in their holding said when they found that the nunc pro tunc order, this is what the chancellor said, and this is what I'm going to do because he can't bring a lawsuit his own name, that's the nunc pro tunc order. He refused to make any determinations hear any arguments on that. So we were unable to complete the record, even though he just wouldn't hear it. And so what he asked us to do was... Well, he didn't ask us, but he said that if you intervene in the conservatorship case, and this is what the chancellor actually said, I will revisit that issue. And the problem, Your Honors, with this standing is that we can go through this whole case. The Madison County Circuit case is currently set for trial in April 2025, and it has gone on since 2020. And 5 years of litigation, and nobody will hear the standing issue, except the chancellor, who was the same chancellor who wrote the conservatorship order in 2009. And I do believe that actually this gets away from, it goes far beyond what this court needs to consider. And that would be an order if the chancellor granted our motion for permissive intervention and denied a motion to vacate or something like that. But it's much more limited what this court needs to consider. This court isn't reviewing that decision de novo. This is not a motion for, this is not a motion that we have an automatic right to intervene. This is a motion for permissive intervention. And 24.02 clearly states that there are two requirements. It is a two-step process. The first one being, does the intervener's claim or defense have a fact in common or a law in common with the main action? We don't even need to get there because the Chancery Court agreed that we do have a common issue of fact and law, our Madison Circuit County case with the conservatorship. In their written order and in their oral order, they failed to make any findings that are required under 24.02 when you apply discretion. So after you get past finding out there's a common law or fact, you then go to the trial court can then use its discretion to either grant or deny the motion for permissive intervention. And the rule in its plain language says in exercising that discretion, the trial court must consider unduly delay or prejudice to the original parties. The chancellor did not do that here.
Are you saying he didn't say the words?
No, Your Honor, he didn't say the words, and there was no argument from the appellee in this case to the Chancery Court on the timeliness grounds that he wrote in his response brief. The court found, and this is from the record as well, that equity looks to the intent rather than to the form. I just don't see 24.02, the intent behind that being what you're trying to use it for in the conservatorship, and denied our motion. And that was all the findings they made. And respectfully, although Chancery courts are granted a broad equitable discretion, they also have to comply with the plain language of Tennessee Rules of Civil Procedure, including and established statutes. And here, our argument is that the Chancery Court did neither.
I mean, there seems to be a sort of an element of futility here. I mean, our case today is just about permissive intervention, which is abuse of discretion standard, as you acknowledge. But it seems pretty clear that the chancellor in this case intended for this conservator to have the power to sue on behalf of Mr. Harris. So, you know, I just can't help but reflect that even if we were to say, well, they erred, you're going to end up with a chancellor that's not going to be very receptive to the idea that they should set aside their order granting the conservator power to pursue this cause of action.
Your Honor, it's not futile, because if this court were to grant our motion of permissive intervention, and we filed a motion to vacate the order, in complying with Tennessee Supreme Court case law, he must strike his nunc-pro-tunc order. It was done incorrectly. And at that point,
well, but another way around that is the chancellor could very well say, well, yeah, I didn't say the words, but that was my intent using the including language.
Intent is not enough. The statute itself states that an order must enumerate the rights, and if not enumerated specifically, then the conservatee retains that right. And I'd like to cite Harris versus Metro Government in Nashville, which I cite in my primary brief and in my reply brief, which admittedly is a federal district court case, but in Middle District, Tennessee, applying Tennessee conservatorship law, and the same issues were present in that case. The words "without limitation," the court said, you know, I intended for him to have the right to sue be removed, and the federal district court said, you should have said something in the order. You should have listed it explicitly and struck the conservatorship order.
But in this case, the circuit court, where the litigation is actually pending, says, not only am I, to some degree, basing my decision on what the chancellor does, but I'm basing it on Rule 17.03 of the Tennessee Rules of Civil Procedure. So consequently, disregarding whatever the chancellor did, you're still in.
Well, Your Honor, it's also...
So that's why I'm saying you've got two bites at the apple.
Your Honor, I don't agree with that,
That's
but I'm out of time.
You don't have to agree with me.
Thank you, Your Honor. Your Honors.
Thank you.
Good afternoon, judges.
Good afternoon.
My name is Bill Bruce. It's a pleasure to be back up here. It's been a little bit. And for a change, I'm not arguing about whether or not notice requirements were met under 2926-121 or whether an expert's qualified. I want to address a couple of points that Ms. Bornstein made, and I think inaccurately. First, based on the chancellor's interpretation of his own order from 2009, the original order did remove all of the rights from Patrick Harris, who, as the court has pointed out, is an individual who was in the care of then the Department of Mental Retardation, afterwards the Department of Intellectual and Developmental Disabilities. He's impaired. He's got psychiatric problems on top of having the misfortune of having mental disabilities. He needs to be protected from himself. He needs someone to vindicate his rights. So when that order was drafted, it said the rights transferred to the conservators, and should include without limitation, without limitation, the rights to make purchases, enter into contractual relationship, hold a Tennessee driver's license, to give or refuse to consent to mental medical and mental examination and treatment and hospitalization. And the Chancellor confirmed his intent was to remove all of the rights from Patrick Harris and transfer those to his conservators. So I agree, it's two bites at the apple. This issue was raised, and I don't know if these judges, this panel, considered the motion for interlocutory appeal in the tort case. But as Your Honor obviously has read and has noticed, Judge Stafford, in the tort case, contrary to what Ms. Bornstein said, the trial court, Judge Howell, did not base his decision on the 2025 order, the January 2025 order clarifying the 2009 order. Judge Howell based his decision on the plain language of Rule 17.03, and I admit I'm paraphrasing. Whenever there is a conservator, the conservator may bring suit on behalf of the ward, whenever. And I made the point in the tort case during the argument there that the language of the Tennessee Rule of Civil Procedure 17.03 is different from the federal rule. Federal rule does not have the word whenever at the beginning of the rule. And so there's a difference between the rules that the federal court, in the case that Ms. Bornstein cited to, in that federal case, the rule was different. Another couple of differences are, in the federal case, there was no catch-all phrase, no without limitation or do any other act of legal significance type of phrase. That wasn't present in the federal case. So that's a big distinguishment. And in fact, the Tennessee case upon which the federal district court relied did find that there was the do any other act of legal significance catch-all phrase, which is why the Tennessee case allowed the conservator to go forward. Another small point, and this was raised in front of the Chancellor, the statute on conservatorships has been amended between 2009 and 2025. The version that Ms. Bornstein recites does have a list of rights that are to be enumerated, though it doesn't preclude a catch-all phrase, and I would submit does not supersede Rule 17.03's grant of a right to a conservator to sue. I did acknowledge to the Chancellor, and I will acknowledge to the three of you, the version of the statute that was in place in 2009 did say you are to enumerate the rights. It just did not give a list. My position is that the 2009 order, the phrase to the rights to be transferred shall include, comma, without limitation, comma, meant that all rights were transferred. And Chancellor Cole, who heard both of them, clearly agreed. That was his position. So I think that, number one, it is a second bite at the apple. It's futile. But number two, there was no abuse of discretion. First, timeliness was raised in my written submission to the Chancery Court, and the raising of this issue by A+ Care was not timely, and that's a threshold issue. They didn't raise it until, even generously, they knew that Bertha Walker, as a conservator, was suing on behalf of Patrick Harris in docket number C22-37, the currently pending tort case, no later than February the 11th of 2022, and A+ Care did not raise the issue for 2 years and 9 months. So they're not timely. Even if timely, the Chancellor's decision does have a basis in law or in fact. The Chancellor looked at the maxims of equity, and as I pointed out in my brief to the court, I cited one recent case in which Gibson Suits in Chancery is cited as law in Tennessee, and in the footnote I pointed out how many of them I found just with a simple computer search of our case law. There is a basis in law. In fact, it's not an arbitrary or illogical decision by the judge. The judge is looking at the realities of the case. This intellectually challenged and psychiatrically challenged individual who can't make purchases, he can't drive, he can't enter into contracts, he can't hire a lawyer to advance his rights. He can't consent or refuse consent to medical treatment. That short list clearly indicates that, yes, the chancellor did mean to remove all the rights. It makes sense. There's a final argument that the order was deficient. I pointed out to the court that Rule 52.01 does not require written findings of fact or conclusions of law as to motions, and this is a motion. This is a motion to intervene. So I submit that there's no defect, but even considering that, the transcript was made part of the order by reference. So you have everything that the chancellor said during that argument and during his ruling and during his findings to support the order. And finally, to the extent nunc pro tunc is an issue, which I don't really think it is, because in the tort case, the court didn't rely upon it, and the chancellor's clearly expressed his statement. The issue or the questions or the argument is made by counsel opposite that there's no writing or memorandum. Yeah, there is. It's the order itself. The chancellor is simply saying, it says without limitation, and this is what I meant for without limitation to mean. It means unlimited. So for all these reasons, Your Honors, I think that the motion to intervene was properly denied. There was no abuse of discretion, and under the standard of review for this, the court is to presume that the decision below was correct and look at the evidence in the light most favorable to upholding the decision. If Your Honors have any questions, I'm glad to answer them. Otherwise, I don't want to take up more of the court's time than is necessary.
See no questions. Thank you.
Thank you, judges.
Your Honors, this court reviews the decision from the Chancery Court, not de novo, as stated before, but abuse of discretion. The Chancery Court wouldn't have been able to consider, in its opinion, the timeliness argument because those timeliness arguments were never made. You have the record, and the argument that timeliness may have been brought up in his brief, it was not brought up in the 3-hour oral argument that we had, and so the Chancellor had no opportunity to do so. The Tennessee Supreme Court cases cited in my primary brief and reply brief, Coker, State versus Williams, in re Estate of Thomason, all of those courts, when reviewing a motion for permissive intervention denial, only relied on whether the trial court had utilized if a permissive intervention would cause some unduly delay or would cause prejudice to the original parties of the original action. And we submit that it wouldn't be an unduly delay because a conservatorship by statute doesn't end until the conservatee dies, or a modification of the conservatorship, meaning the conservatorship would be terminated. And that has not obviously happened because we're here today on a nunc pro tunc order removing additional rights. And then the other, prejudice, and quite frankly, Your Honors, if A+ Care isn't able to permissively intervene in this case as a byproduct, it'll actually end up prejudicing the most important person here, who is Patrick Harris. He is the star of this conservatorship. And if this court submits to the arguments of the appellee that the term without limitation could just mean I'm taking away every single right you have, how far does that extend? What happens when an order of conservatorship lists out specific rights and then has the word etc. after it? Does that mean a conservatee who thought they had rights for 15 plus years has none? Mr. Patrick Harris was a person supported at A+ Care. He was making daily decisions. He was choosing what to eat. He was getting an allowance. He was spending money. He was deciding where he wanted to go.
Is any of this in the record?
No, Your Honor, but it was brought up
We don't need to hear it.
by appellee. But my point here is that the prejudice really is not to the original parties of the original conservatorship, but there is a risk that if we are not allowed to permissively intervene, that the Chancery Court has established a precedent that they can just go back and change conservatorships at any time.
But you're saying this, the interest of your client in intervening in the conservatorship is not solely to challenge the nunc pro tunc order, but to vindicate Mr. Harris's rights?
No, Your Honor, that our sole purpose is to intervene because the nunc pro tunc order
Was
affected
improper.
A+ Care in the Madison County Circuit Court case, which the Chancery Court agreed with. But as a byproduct and an ironic twist of fate, it ends up protecting, I'm going to use the word protecting Patrick Harris more so than his conservators are doing by removing additional rights that Patrick Harris had since 2009 and went back and removed those retroactively without due process.
I think you made that argument to Chancellor Cole, and he did not find that to be very sufficient.
I did, Your Honor, and I made that argument at the Chancery Court level, but the Chancellor also didn't apply the required. It's not permissive in 24.02 to consider unduly delay and prejudice to the original parties. The Chancellor had a hard time, and this is shown in the written order, and kind of putting into words what type of discretion he was using. It was more of a feeling of intent of how you're using this rule, and that's written in the, well, I should say transcribed in the oral argument. But even in the written order, the Chancellor signed an order that stated, and I'm just denying it in my equitable discretion, because the Chancellor didn't give any specific reasons, because unduly delay and prejudice all weigh in favor of A+ Care. And are there any other questions?
Thank you.
Thank you so much.
Thank you, counsel. We'll take this matter under advisement and attempt to get you an opinion at the earliest possible time. Thank you. You may call the next case, Ms. Angie.
Timothy Williams versus Leanne Sykes.